One client lost the case, kept the money, and here's why. The structure was in place before the lawsuit, and the legal control flipped exactly when it needed to. So stay with me, and I'll show you 3 real cases and the specific moves that made the difference. Hi, I'm Kevin, the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. For 34 years in this field, nearly 30 setting up Cook Islands trusts. We've helped clients protect what they've built, and we've set up more Cook Islands trusts than any firm in the world. And today I'm going to walk you through 3 anonymized real-world case studies where someone lost in court and yet kept their money, and why timing and structure mattered more than bravado. And please do me a favor, check right now to see if you're subscribed to this channel. It really helps me out a lot. And we give you weekly no-fluff breakdowns and real case studies. And if you want the companion case study pack with diagrams and checklists tailor-made to you, you can visit us at assetprotectionplanners.com and schedule a free consultation with one of our attorneys or consultants if you have $500,000 or more to protect. Okay, ground rules. What this video is and isn't. This is not about evasion. It's about lawful, preemptive planning. Now, courts care about timing and intent. So if you move assets after a legal fire starts, you may hand your opponent a flamethrower called fraudulent transfer. But if your plan existed in peacetime, operated consistently, and has real governance, it's not just paper, you radically improve your odds. So the cases I'll share span operating companies, real estate, and marketable securities. All US-based clients, all high net worth, all skeptics at first until they saw the math. And nothing here is legal or tax advice. This is education. So speak with one of our attorneys on staff who can discuss your facts directly. Okay, cliffhanger number 1. In case study number 2, the judge's order literally says judgment for plaintiff, yet the assets didn't move an inch. And I'll read you the line that mattered and why we cared more about control than ownership, so stay with me. Okay, in a 2-minute primer, the structure that flips control at the right moment. So here's the architecture that we prefer for serious protection. A Cook Islands Trust, we'll call this CIT for Cook Islands Trust, with the Cook Islands LLC inside of it. During calm waters, you, the client, that's you smiling, are in control. So you hold the reins, you make the investment decisions. But when a legal storm hits, our licensed, bonded, trustee company law firm over here in the Cook Islands steps in to protect you under the duress clause. So your day-to-day control yields to your professional, lawful protection only when necessary. So when the threat passes, control returns. That flip from you to the foreign trust company law firm under a deed that anticipates litigation is where the leverage changes. For U.S. real estate, we don't jam titles offshore. And the reason we don't, that won't help because the real estate's right here. So what we do is we strip the equity. So we take an LLC, record equity stripping liens against it, all the properties, and then if needed, we get a third-party lender to buy those liens and put the proceeds in the offshore trust structure that we just did in the diagram. So for U.S. real estate, we place properly documented liens, often initially payable to the Cook Islands LLC, and if needed, season with third-party lenders who can purchase these notes so they're not friendly paper. For brokerage accounts, we use a mix of domestic and foreign custodians with clear instructions and a duress protocol so there's no scramble on the worst day. Okay, case study number 1, the developer who lost the lawsuit and still sleeps at night. So profile, David, mid-50s, general contractor developer, net worth $8.5 million, 2 LLCs, 5 rental properties, and an operating company that occasionally took personal guarantees, a habit that we corrected. So instead of 1 LLC per property, he only had 2 with 5 properties in them. Now, a subcontractor injury turned into a multi-million-dollar suit. His GL carrier defended, but exclusions and finger-pointing multiplied defendants. So 2 years before the incident, David became a client after watching a colleague get totally cleaned out. Good timing. So the plan was implemented 2 years pre-suit. the Cook Islands Trust, Cook Islands LLC inside of it with his bank accounts, brokerage account, and so on inside. David was the manager under calm conditions, equity stripping on the properties. We recorded mortgages to the Cook Islands LLC on 2 properties, arranged third-party purchase of the notes to the seasoned paper, operating company, the company he ran his business in, housekeeping, clean separation of entities, elimination of casual personal guarantees, and updated contracts with indemnities to protect him, and proper certificates. Brokerage, we split custody. A chunk stayed in the domestic LLC that we set up for him, and the bulk of it went into the offshore LLC inside of the offshore trust, so that when the U.S. courts say, give me the money, our offshore trustee law firm says, nope, you don't have jurisdiction here. And of course, this trust is all pre-wired with duress instructions, so when this happened, he knew exactly what to do. So here's what happened. The case dragged on. Mediation failed. A jury returned an adverse verdict against several parties, including David's operating company. Post-judgment discovery began, subpoenas for bank statements, property records, ownership charts. The other side expected low-hanging fruit. They found liens on the real estate, a trust they couldn't domesticate, an LLC manager who, by design, lost discretion the moment litigation hit. So our trustee stepped in as per the duress clause. David didn't move anything post-judgment. The instructions were already in place. Now here's why all this worked. Timing. The structure pre-existed 2 years before. Courts see continuity, not panic. Control flip under duress. A foreign trustee, not David, made decisions. Domestication hurdles went up. Collection levers went down. So equity illusion busted. Plaintiffs love the properties, but the liens love them even more. Net collectible equity looked thin. So we put every property into a separate land trust for privacy of ownership. We made the beneficiary of each land trust a separate LLC for separation. We recorded the equity stripping liens against the properties, including the personal residence. There was nothing to take. So the number to settle fell into rational territory. Behavioral edge? Plaintiffs chase easy wins. When the path is uphill, the appetite to spend more shrinks, and the vast majority of civil cases resolve in settlement anyway. So the outcome? Judgment entered. Settlement reached for a fraction, paid from cash flow that didn't jeopardize the core asset. So David finished 2 projects, rolled forward, and now he swears by boring legal prep, the way pilots swear by checklists. Okay, cliffhanger number 2. In the next case, the client never moved a single asset after getting sued, and that's exactly what kept them. I'll show you the judge's line item and the trap most people fall into that he avoided. Okay, case study number 2, the physician with a judgment, a practice, and zero panic. Profile: Dr. S, late 40s, specialty practice owner, $5.2 million net worth, 2 homes, taxable brokerage, a practice with equipment financing. He did carry malpractice insurance, but an unusual claim pierced that coverage. He had heard of asset protection, but assured, I'll never need it. After attending a conference where I spoke, he set up a plan 9 months before the issue surfaced. Okay, here's what happened. Plan implemented, like I say, 9 months pre-suit. Cook Islands Trust plus Cook Islands LLC with Dr. S as the manager, under calm times here. Account segmentation. So core working capital remained in the practice entity. Investment assets were titled to the LLC that's inside of the trust here. So it's protected. So duress instructions, standing letters with custodians upon legal trigger, pause distributions, and honor the trustee directives. Personal guarantee audit, we replaced open-ended guarantees with limited secured guarantees whenever possible. So what happened? The doctor, he lost at trial. The order read, judgment for plaintiff. And opposing counsel assumed a victory lap to the bank. Now, post-judgment discovery met a wall. The brokerage obeyed existing instructions, no distributions, absent trustee authorization. The client didn't touch accounts post-judgment. There was nothing to claw back as a recent transfer because there was no transfer. The trustee, standing outside the U.S. jurisdiction, evaluated risk and maintained the protective posture lawfully. The doctor kept everything. So here's the line that mattered. Here's the sentence from the judge's order that we cared about. Nothing herein compels non-party foreign trustees to act. This is not a magic spell. This is the recognition of jurisdiction. Control, not just title, was offshore at the right moment, and that's why this protected the doctor. So again, why he kept the money despite losing. No post-suit activity. He didn't move a penny after the lawsuit began. The structure was already in place. The duress protocol simply activated. Foreign control under duress. The trustee's duties run to the trust deed and the Cook Islands law, not a U.S. courtroom preferences. Plaintiff economics, collection turned expensive. The realistic settlement number dropped. He negotiated from strength, not fear. So put the doctor in the driver's seat just like you want when you're protecting your assets. Outcome, he resolved with insurable-like numbers, kept his practice, kept his portfolio, and later told me, I used to think asset protection was for people with something to hide. It turns out it's for people with something to keep. Okay, cliffhanger number 3, the next case is really the toughest, a real estate investor who waited too long. Now, we still helped, but the difference between peacetime planning and panic planning cost her 7 figures, and I'll show you where she bled and where she didn't. So case study 3, the investor who delayed and paid for it. Profile, Marisol, early 60s, retired executive turned real estate investor, $12 million net worth across multifamily and triple net retail. Now, she had heard of offshore trusts forever, but a friendly attorney told her, you're fine, everything's in LLCs. And then a tenant injury plus a lease dispute collided into a multi-claim nightmare. She called after receiving a demand letter, not ideal timing. Now, what we could do post-threat was limited. Operating discipline, we cleaned up the intercompany loans, documented corporate formalities, and stopped the casual commingling that plaintiffs love to exploit. So selective equity stripping for properties with genuine refinance viability. We recorded new debt were commercially reasonable. And 2 cases were arranged for a third-party lender to purchase the notes from our financing affiliate, converting friendly liens that we had placed on the properties into real liens with third-party lenders. So liquidity triage, we moved nothing that would look like a sprint to hide assets. Instead, we used existing documented credit facilities to build cushions where permitted. Okay, future pacing the trust. We did establish the Cook Islands Trust, an LLC, but we treated it as a shield for what would be earned and accumulated going forward, not a magical fix for yesterday's exposure. But we're still able to protect everything. So here's what happened. 2 suits landed. She settled 1 at premium because the property equity was fat and the lien work, even though it started, hadn't seasoned. The second suit targeted separate LLCs where we had stronger paperwork and less equity. The one that settled near defense costs and the painful check she wrote, think 7 figures, but smaller than the number plaintiffs had first demanded. And the reason is she contacted us too late. The other side had already slapped Liz Pendens on the property with the fat equity, so really nothing we could do there because she contacted us too late in the game. So the lesson, LLCs are not force fields. Plaintiffs don't always need to pierce the veil. They target the LLC's own assets. If the equity sits there, it's still reachable. So seasoning matters. A note transferred to a third party today looks very different than one that's been held in service for a year. Trusts are not time machines. Post-threat planning can still be valuable, but it mostly protects the next dollar and not the last one. Okay, here's the outcome. Marisol is now jokes about paying tuition. She built a forward-looking shield, trust plus LLC structure, staged equity stripping, split custody on investments, and a personal rule, no personal guarantees ever without counsel watching. So she sends us holiday cards to our team. I kept the first one on my bookshelf to remind clients sooner is cheaper. Okay, here's the playbook and what to do now is an actionable checklist. If you're a business owner or investor with, say, $500,000 or $1 million to $20 million in net worth, here's the practical sequence that we use. Calm waters, first, map your balance sheet. Operating company, holding entities, real estate, securities, your intellectual property, guarantees. If you don't have a one-page map, you don't really have a plan. So just map it out. Map out what you have. Write down what you have. Okay, next, choose the core shield. We lawsuit grade protection. We deploy the Cook Islands Trust with the Cook Islands LLC inside of it. You initially manage the LLC when skies are blue, and then our licensed bonded trustee company law firm steps in under duress. It's easy as that. Real estate, we strip the equity. Don't export the title to offshore. That's not going to help because the real estate's right here. So we have to strip what's valuable, the equity. Record commercially sensible liens, and then where appropriate, we use third-party lenders to purchase those notes so the paper stands on its own and the proceeds go into your offshore trust. Brokerage, segment and custody. Duress protocol, keep some domestic for convenience and place a portion with a foreign custodian, and that's where the bulk of your funds go. Pre-authorize, pause, and protect instructions that do not require your signature on the worst day. Okay, guarantee audit. Remove casual personal guarantees. Replace with caps, collateral, or carve-outs that you can live with. Personal guarantees are really a killer for a business person. Okay, governance drill. Minutes, resolutions, indemnities, insurance limits. We take care of these things. We help you with your formalities as an extra service that we provide. Incident reporting, a tidy house is left less appetizing to a hungry plaintiff. Dress rehearsal. We run a tabletop exercise. Okay, lawsuit hits Friday at 4 p.m. What happens next? Nobody should be reading the manual when you're flying a plane during turbulence. You should already know this stuff. And that's why we have it pre-planned. Our clients, they're ready to go when the lawsuit hits. So for free information, go to assetprotectionplanners.com right now. Grab the free case study pack, and we'll put together a plan that's right for you. If you have $500,000 or more to protect, the reason is because that's the amount that really makes sense to engage the solutions that we offer. That's why we have the $500,000 or more announced. But just so we're talking to the right people, and your time and our time is best used. And we also have a checklist that you can hand to your CPA and attorney. So if you want our team to run a private review, there's a consultation form on our website. Okay, Skeptics Corner, answering the tough questions. Okay, next, first question. Is this just hiding? No, hiding is chaotic and usually illegal. Planning is documented, commercially sensible, and done in advance with professional trustees and real transactions. Next question. Aren't trusts just for billionaires? Well, our typical client is a builder, a physician, an e-commerce founder, or investor with $1 to $20 million who wants to stay that way. Billionaires didn't invent prudence. Okay, what if a judge orders me to bring the money back? Well, under duress, you don't control the assets. A foreign trustee company law firm does. Very highly regulated, very trustworthy. Like I say, I've been doing this for 30 years. Never had anything bad happen to a client from our Cook Islands trustee. Courts generally won't punish you for what you can't do, especially when the structure predates the dispute and you've already acted in good faith. Okay, will this scare banks or partners? Well, we design this for normalcy and calm times. You manage the LLC, you pay vendors, invest, refinance, live your life. The heavy armor only appears when the arrows fly. Okay, recap with cliffhanger. Okay, resolve case number 1, lost at trial, kept wealth because the plan existed 2 years early and control flipped on cue. Case number 2, the order said judgment for plaintiff, but nothing compelled a non-party foreign trustee to act. No post-suit transfers, nothing to claw back. Case number 3, waited too long. We reduced damage, but she paid tuition. Now she protects the next dollar with discipline. So if you only remember one line here, make it this. Timing beats courage. You don't need to be fearless. You do need to be early. So if you found this useful, subscribe now. I publish detailed legal mechanics every week as the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. We've set up more Cook Islands Trust than any firm in the world, and nearly 30 years of doing it has taught us what actually holds when the pressure is on. So download the free case study pack. Call our team if you want a tailor-made plan for you. If you have $500,000 or more to protect and you really need this, you're serious, not just curious, give us a call. Visit us at assetprotectionplanners.com. So here's the final word. Your opponent needs 3 things to beat you: time, leverage, and an easy target. Good planning takes care of all 3. So start in peacetime, fly the checklist, and if a verdict ever goes the wrong way, you'll still be able to look out at the water, sip your coffee, and say, we planned for this.